former president to answer questions. Is that correct?
Correct.
Great. And so does every other member of this committee. We want the former president to answer questions of this committee, and we want not just the former president, but everyone to follow subpoenas of this committee. So let's agree on that. But to be clear, President Clinton, the former president, has submitted a signed declaration. He's offered to sit with you and me and answer questions. He's offered to have staff in the room to transcribe and be there while those questions are being answered. And his request was to do it in a dignified way. Your concern, as you brought up in your last comments, was that he was unwilling to do a recorded transcript. That's actually also not true. And to be clear, there's been public reporting, including in articles that came out over the weekend, that they have not ruled out a recorded transcript. I want to ask the president questions. Chairman Comer, I want to ask President Clinton questions. Don't you?
That's why we're here.
I want to ask President Clinton questions and a recorded transcript and with our members of our staff. Would you like to do that also?
May I make a comment on the transcript? They have not agreed to a transcript. Staff notes are not equivalent.
They've actually made public reporting.
So they're wanting me to make note. They said, okay, Comer can take notes, but they've called us all liars, and you know how the Clintons have gone on offense, and look, they don't get to make the rules. We make the rules.
Can I have the rest of my time back?
Yeah. Go
okay,
ahead.
Thank you. I want to be clear because this is an email actually that from the Clinton lawyers. You have this actually. To be clear, at no point were we opposed to the creation of a record of the interview, which is why we offered to allow the note takers previously. They go on. You have this email, sir. So I guess my question to you is, do you want to sit down and ask President Clinton questions? Actually, can I have my time back?
Will the ranking member
We'll recognize Garcia, then Mr. Donalds will be next. So
thank you. So my question to you, Mr. Comer, again, is if we want to actually ask questions of President Clinton, of which those of us in the minority want to do, then let's get him in. Let's negotiate a recorded transcription of that interview to further our investigation. I thank you for the yield, Mr. Lynch.
Chair, time's expired. Chair recognizes Mr. Donalds.
Chairman, point of clarification. Both President Clinton and Secretary Clinton were subpoenaed by this committee to come in for a transcribed interview. Is that correct?
For a deposition.
Excuse me, for a deposition. Chairman, I've been in these closed depositions a number of times in my time being on the Oversight Committee. I fail to see what President Clinton's talking about with respect to a dignified manner. Every time I've been involved in any of these conversations, even when it was former President Biden's son came in for one of those, and I'm not trying to bring up all the Hunter stuff, it's just a point I'm making. I think everybody just take the temperature down, relax. Even those the closed door depositions have always been held in a dignified manner. Members have had questions outside of questions from committee staff, but members on both sides of the aisle had an ability to answer those questions. Those interviews are recorded. The transcripts of those interviews are provided to the public. I fail to see what special accommodations President Clinton and Secretary Clinton were looking for. Chairman, can you help me understand this? Or even a ranking member. I'm really trying to understand. I'm not trying to make a point. We do too much of that here. I'm trying to understand, because if we're holding a new meeting to replace what the committee already requested, my question is why?
Mr. Garcia is willing to answer the question.
Yeah. Thank you, Mr. Donalds. I appreciate the question. Look, I think the committee first, I'm not here to defend the Clintons, to be clear. That's their job is to negotiate with the committee, and in this case, you have the majority. Their job is to negotiate with the majority on coming in for a binding subpoena, to be clear. But I'll also note that this committee has historically made accommodations for a variety of folks. In fact, I think it is a bit hypocritical that when this very subpoena for the Clintons were actually made, I believe there were an additional 5 to 6 other subpoenas that were issued to numerous other members of former administrations, attorney generals, and so forth. Every one of those other subpoenas, I think maybe with the exception of one, were given special accommodations. In fact, they were actually allowed to just send their responses in writing. Is that correct, Mr. Comer?
That is. May I respond to that?
Yes, in just 1 second. And so accommodations are made. And so while every other folks in that group were given special accommodations, that's been typically the case. And I'll finally say just this. Like you, I want to have President Clinton answer questions. I think they are trying to negotiate that with the majority, and they have been clear that it being transcribed is not an issue. They've not ruled that out. And so let's negotiate with the Clintons and let's get them to answer our questions.
I mean, Chairman, since I guess we're on my time, and by the way, Ranking Member, thank you for that. I appreciate that. Chairman, you were mentioning you were going to inject your commentary with respect to special accommodations that have been made for previous witnesses. I don't know if you want to expound on what the Ranking Member said or not.
I would love to. So, first of all, you talk about ongoing negotiations. We have been negotiating for 5 months. This is clearly a stall tactic, hoping that the time clock runs out and the House flips and that you all let them off the hook. But secondly, you mentioned, and I mentioned this in my open statement, there were names on that initial list with the Summerlee motion and the Scott Perry amendment. Attorney General Holder, Lynch, Sessions, and Garland, as well as Comey, they all complied and had written statements under the penalty of perjury that they had no knowledge of anything with Epstein, that they weren't directly involved in the investigation, and basically had no personal relationship. I think we would all agree the Clintons had a personal relationship with both Epstein and Maxwell. It's from the evidence that we've received thus far from the estate and all the other documents that we have thus far, it appears that Jeffrey Epstein visited the Clinton White House 17 times while he was president, and then post-presidency, it appears that Bill Clinton flew on Epstein's plane at least 27 times. So there's a huge difference between the knowledge and relationship with the Clintons and Epstein and Maxwell versus the former attorneys general. And another note, I don't know if it was Mr. Bell or whoever said that we only are interested in Democrats. We grilled Bill Barr and Alex Acosta, and they are very Republicans. In fact, they were members of the Trump cabinet. Now, I've been on the Oversight Committee 9 years. We've had 4 other committee chairs. We've had since I've been here, we've had Jason Chaffetz, Trey Gowdy, Elijah Cummings, and Carolyn Maloney. I don't ever remember a time, and I could be wrong. If I am, I'm sure you all will correct me, but I don't remember a time when Carolyn Maloney or Elijah Cummings subpoenaed a high-ranking Democrat to come in for a grilling. So to imply that this is partisan, that is just simply not true. We've already had 2 very the former Attorney General of the United States under Trump and the former Labor Secretary and U.S. Attorney. So we've done that. And then one other thing with the Clintons, and I'll yield back. One of the arguments the Clintons made, Mr. Garcia, was that our subpoenas were unlawful. Do you agree that the subpoenas we issued the Clintons are unlawful?
I believe that all of our subpoenas that we have issued have been lawful, sir.
Okay. Just any other members seek recognition?
Ms. Brown, sir.
Ms. Brown. Ms. Brown.
Thank you, Mr. Chairman. It's clear to me that the purpose of this meeting today is just to continue this committee's agenda of political theater, plain and simple. Democrats have been very clear, abundantly, repeatedly, and without room for ambiguity. We want to hear from anyone who has information about the Epstein crimes. And yet, when President Clinton and former Secretary Clinton offered to cooperate with this committee to submit sworn statements, to provide what they know, to engage in good faith, the majority said no. And that's what brings us to why we're really here today. The majority is rushing to hold in contempt two private citizens who have demonstrated their desire to cooperate with this committee and who have called for the release of every file on Jeffrey Epstein, all while the Department of Justice and Attorney General Pam Bondi are breaking the law in plain sight. Here are the facts. The DOJ was required by statute to release the Epstein files by December 19th, 2025. The deadline has passed by more than a month. And what have we received? 1%. 1% is not compliance. 1% is not transparency. 1% is a cover-up. What about the 1% they actually release? We've seen redactions that are extensive, unusual, and very likely illegal. And what's more, the Epstein Files Release Act, passed by supermajorities in this Congress and signed into law by this president, required the DOJ to send a report to Congress by January 3rd, 2026. More than 2 weeks later, what have we received from the DOJ? Nothing. So if my colleagues on the other side of the aisle were really serious about uncovering the truth and government and accountability, we would be demanding answers from the administration. We would be demanding answers from Attorney General Bondi. We would be demanding the release of the 99% of the Epstein files still sitting at the DOJ. So I have some very simple questions. Where is the subpoena for Attorney General Bondi? Where is the hearing on DOJ's failure to comply with the Epstein Files Transparency Act? Where is the accountability for the redactions page after page after page? This vote feels less like oversight and more like a distraction. A distraction from the DOJ's lawlessness, a distraction from a broken promise of transparency, a distraction from the embarrassment of a co-equal branch of government choosing complicity over accountability, and a distraction from survivors who deserve this truth. If this committee is serious, then we must hold the Department of Justice accountable. Release the files, all of them, and stop playing politics with justice. Survivors deserve better. And with that, I yield the balance of my time to the ranking member.
Thank you, Representative Brown. I just want to Chairman, I want to just respond of who the subpoenas you have chosen not to enforce. Alberto Gonzalez, who we subpoenaed on that same day, I believe you did not enforce. Eric Holder, of course, former AG, did not enforce. Loretta Lynch, you chose not to enforce. Jeff Sessions, you chose not to enforce. Merrick Garland, who I think it'd be important to have answer questions, you chose not to enforce. Robert James Comey, you chose not to enforce. In fact, I have Attorney General Gonzalez's letter. It says, "Dear Chairman Comer, this letter is to confirm that consistent with my conversations with the committee general counsel, I have no present memory or decisions or conversations related to the investigation and prosecution of Epstein matter during my tenure as U.S. Attorney General." He, of course, was the Attorney General when the whole Alex Acosta U.S. Attorney matter was in front of a critical time in this investigation. Now, you chose not to enforce that because you mentioned that this letter is under penalty of perjury. The declaration that Clintons also made and sent to you to answer some of those questions were also under penalty of perjury. I just want to clarify that. And then with the remainder of my time, Mr. Chairman, I think it's important to note that you talked a lot about the importance of our subpoenas and that we should all support this committee's subpoenas. And I agree with you, sir, and I want to hear from the Clintons. It's also important to note that we have members of this committee, Congressman Jim Jordan, Congressman Andy Biggs, Congressman Scott Perry, who are obviously very outspoken, which we like to engage with. Now, they're not here, and that's okay. Now, you also know, sir, that all three of them defied legally binding subpoenas issued by the January 6th committee relating to their efforts to overturn the 2020 election. So we should be clear that the majority chooses to be very selective on which subpoenas they want to enforce or talk about. We have members of the majority that themselves have defied subpoenas. So once again, I ask you, Mr. Chairman, let's ask President Clinton the questions that we have. Let's have him come in and testify in a way that we can negotiate, and let's get all the release of the files done immediately. Thank you.
Would you yield? Could I respond to that?
Sure, I have no more time, but I'm happy to respond.
So you say we didn't enforce the subpoenas. We did enforce. They complied and testified under the penalty of perjury that they had no knowledge. Now, the Clinton declarations were short bullet points, almost like talking points. And the evidence is clear that the Clintons did have relationships with them. Now, again, I've said publicly millions of times, there's no one's accusing the Clintons of wrongdoing, but the fact that they were that close, and the fact that I've never seen a sit-down interview with Bill Clinton where he's answered questions about his relationship with Epstein and Maxwell like the current president has. So we have complied and enforced all of our subpoenas, 100% of our subpoenas. So I just want to make that very clear.
Can I respond to you, sir? Sure. Just to be clear, you're talking about two declarations. The declaration that you chose to use as something that you moved on to not bring him in was 1/6 the size of the Clinton declaration. I'm looking at the Alberto Gonzalez response to you, sir, that you chose to dismiss, and it is one sentence long. One sentence long. You just pointed out the Clinton declaration, which is 6 times as long. And so I just think you are using interesting points to make comparisons. Let's just be clear and get back to the facts. Let's bring President Clinton in to have a conversation with this committee. You are instead choosing to try to prosecute President Clinton and send him to jail, which is part of criminal prosecution, before having him answer questions to this committee. Him and his team have been trying to negotiate. We want to hear from President Clinton. I'm not sure that you do, sir.
You don't think I want to hear from President
Chairman
Clinton?
Comer, can I, Chairman?
But before I recognize Ms. Luna, who'll be next, I believe, are you willing to accept those bullet points as testimony, or do you want to hear from Clinton?
I want to hear from President Clinton.
Then I don't know what the point is of talking about their bullet points. I mean, that we all know they had a relationship. So.
Well, sir, I'm just responding to the fact that you mentioned that you're dismissing other legal subpoenas with 1-sentence answers, and you're the one that pointed out the Clinton's declaration, which is also under penalty of perjury.
Do you think that Eric Holder or Lynch or Jeff Sessions or Merrick Garland had more? I mean, do you want to bring them all in?
I would love to have former Attorney General Merrick Garland in front of this committee to answer questions as to why more of the files weren't released. I've actually said that publicly. And so, sir, I think what it comes down to is we all want to get to the truth. We all want justice for the survivors. And I think more information is better. And so I think our position is that it is clear to me that President Clinton is negotiating to come in front of this committee. And it may not be exactly what you and the lawyer and your team want to see as far as that negotiation, or you're not satisfied with the progress, but they continue to negotiate. They have not rolled out a transcript. Let's get them in front of this committee. Thank you, sir.
Chair recognizes Mr. Gill, then Ms. Luna. Mr. Gill has a bigger. Go ahead. No, Miss. Who's next? Ms. Luna. Go ahead, Ms. Luna. Then Ms.
Thank you, Chairman. I'd just like to remind the American people that I was the member that made the motion to hold Merrick Garland in contempt of Congress, and every Democrat voted against it. And in addition to that, 3 of my Republican colleagues voted against it, one of which did not come back because his voters decided that he was too swampy for them. So
okay.
I'd just like to point that out. But aside from that,
Ms. Luna, it's been pointed out to me you've already had 5 minutes. Somebody will probably yield you some time. So I've got to.
If I could just finish real quick. If we're looking to see why the files have not been released yet, look no further than the judge, Engelmeyer,
I'm sorry, Ms.
who's actually been
Luna.
responsible
I'm sorry.
for denying
If someone can yield you some time.
Special counsel. I'm just saying, I'm making a point.
All right.
So this is all political.
So we haven't
games
recognized
here.
the Republican on this. Miss Mace, do you want to be recognized?
That would be great, Mr. Chairman. I have a number of documents I would like to enter into the record this morning with unanimous consent. First of all, I want to ask my colleagues on the other side of the aisle to stop playing politics with justice. Not a single one of you voted for your own party to be held in contempt. I'm the only member of this body, of this committee, that has held both Republicans and Democrats alike in contempt for defying a congressional subpoena. So the hypocrisy is real, and I don't want to hear anyone on the other side of the aisle say no one is above the law here on this. We're talking about human trafficking, sex trafficking. We're talking about children, girls as young as 14 being assaulted, being trafficked by wealthy and powerful people. This is not political. This is personal. This should be nonpartisan. We should be working on this together. And it's incredible that we're politicizing rape, we're politicizing sex trafficking, we're politicizing this entire Epstein thing. And it just, as a survivor, I'm telling you, it should not be. And I've done a lot of work, Mr. Chairman, in advocacy and writing legislation for victims of abuse, male, female, and children, man, woman, and child. South Carolina, my home state, Mr. Chairman, has a huge problem with not with all sorts of violent crimes, but sex trafficking in my state is up by over 400%. We have domestic violence in our state where you can't get a trial. And there was a case last year where a woman 2 years ago was kidnapped by her boyfriend, beaten to a pulp, her face just beaten in. 2 years after he kidnapped her and beat her, he murdered her on Mother's Day because our local solicitor refused to prosecute that case. And I have rogue solicitors and prosecutors and attorneys general who aren't doing anything to protect the people of South Carolina, women and children especially. Recently, my attorney general prosecuted a case against convicted pedophile Donald Gresh. Donald Gresh was convicted of having 1,900 images of toddlers as young as 3 being raped by animals. Donald Gresh, under the prosecution of my attorney general Alan Wilson, served 1 day in jail. 1 day. Donald Gresh isn't the only pedophile, convicted pedophile, that we prosecute like that. My attorney general, Alan Wilson, prosecuted this case. This is Travis Reed Gay. Well, the other thing, too, is that Donald Gresh, he was facing 60 years in jail, got 1 day. Travis Reed Gay was facing 70 years, 7 charges and 70 years in jail in South Carolina. My attorney general prosecuted this case. He pled guilty in November, didn't serve any time. He got probation. He violated his probation 11 days later, and if he violated his probation, he was to serve time in jail. The magistrate or judge, probably didn't have a law degree, let him out hours later. He has not served any required time for this kind of thing. And I did a press conference with a bunch of moms, over a dozen moms last week in Charleston, South Carolina, and there was a local media blackout. I asked, was it my attorney general who prosecuted this case and led this pedophile out on the streets? Was he the one that led the media blackout? Well, I want my attorney general in my state to know that a young child came forward after seeing my press conference and recognized this man. She filed a police report the same day because he allegedly followed her in a park the week before. This is Scott Spivey, killed, shot with a bullet in the back, shot at 17 times, not prosecuted by my attorney general. So I'm going to ask unanimous consent, Mr. Chairman, to enter those 3 images into the record. This is Weldon Boyd. This is Scott Spivey's killer who shot him in the back and has never really been investigated or prosecuted for that killing in South Carolina. I would like to enter that into the record, Mr. Chairman.
Without objection to order.
This is Logan Federico. She was executed a year ago, yesterday to the day, by a man named Alexander Dickey. Alexander Dickey was a convicted criminal. He had 39 arrests, 25 felony charges. He executed this beautiful 22-year-old daughter of Stephen Federico in cold blood after stealing a gun. If her killer, Alexander Dickey, hadn't been let out by a rogue magistrate or judge or a prosecutor solicitor that didn't care, she would be alive today. Mr. Chairman, I would like to enter her image and her killer's image into the record.
Without objection to order.
I have another image. This is Eric Bowman. Eric Bowman beat his wife and has been alleged and is being investigated for other abuses against women and potentially underage girls. He was just let out free, Mr. Chairman, out of jail in South Carolina. He is a predator. I have reported him to law enforcement. He's under investigation, but I have written bill after bill about predators like Eric Bowman, about voyeurism, about these sort of criminal sexual allegations. I would like to enter his image into the record.
Without objection to order.
I have 2 more.
Can we get it? Your time's expired, but I'll recognize you for a UC later on, because I want to make sure everybody stays within their 5 minutes. Chair recognizes Mr. Bell from Missouri.